Morning everyone, welcome to our webinar. Today we're continuing our series of looking at the impact of Brexit on businesses, and we're going to have a look at what the impact of the Brexit deal or the Trade and Cooperation Agreement is on data protection. So just a few housekeeping points. If you could put any questions into the Q&A and we can pick them up. Also, there is a feedback form in the Q&A, so if you could also fill that in. When you are submitting questions, if you could put your name and email address against it, then if we don't get time to pick them up whilst the webinar is live, then we can come back to you afterwards. So I'm Joanne Bone. I'm a partner in the commercial team here and specialise in data protection. And Grace, who's presenting with me today, she's also a data protection specialist, and she's a solicitor in our commercial team. So moving on in terms of what we are going to cover today. So on the next slide, you'll see that we're looking primarily at the impact of the TCA. The value of the data economy between the EU and the UK is absolutely huge. In 2020, it was valued at in excess of 400 billion euros. So one of the key things that was considered during the Brexit negotiations was keeping personal data flowing. And I think it's fair to say that the Trade and Cooperation Agreement has provided some breathing space in relation to this. It hasn't finally put the issue to bed, and we'll have a look at that in a little bit more detail later, but it certainly has given businesses some breathing space. One of the things I think does need to be recognised in relation to the Trade and Cooperation Agreement, which I will call the TCA, throughout the presentation, is that it doesn't deal with everything. There are a number of ramifications of Brexit in relation to data protection, and the TCA doesn't cover everything. So one of the main things that we'll be having a look at today is what does it cover and what doesn't it cover. So in terms of moving on to the next slide, one of the things that we want to talk about first is a common misconception that GDPR was going to go away. There are a number of businesses that thought once we were outside the EU, this EU piece of legislation would fall by the wayside. And that's certainly not going to be the case. And in actual fact, because of the way in which the deal has worked, it may well be that businesses are caught by two different pieces of legislation. So not only has GDPR not been jettisoned, but in actual fact, businesses potentially are caught by both EU GDPR and UK GDPR. So I'm going to hand over to Grace, and she's going to have a look at that issue in a little bit more detail.
Thanks very much, Joanne. Yes, so as Joanne says, this will be a very short presentation if the answer to this question was no. So following the end of the transition period, GDPR was retained in domestic law under UK GDPR. This is very much in place now and applies to UK established businesses. It's almost identical to the EU GDPR, and the good news is that if you are a UK established business that took your obligations under GDPR very seriously, you put in place comprehensive documentation that you regularly review and update, then there may not be a huge amount for you to do at this stage. However, this is very much on the presumption that you do not have any contacts or clients based in the EEA. And I'll shortly demonstrate that this may not be as clear-cut as you might think. So EU GDPR has not gone away. It continues to apply alongside the UK GDPR. And because both regimes have extraterritorial effect, as Joanne mentioned, you may be caught by both. So in order to consider whether you're caught by EU GDPR, you'll see on the slides that if you're a UK business that continues to sell goods or services to individuals in the EEA, or if you monitor the behaviour of individuals in the EEA, then you will be caught by EU GDPR, as well as UK GDPR. Now, this is where you're selling goods or services to individuals and not to companies. So if you're only selling to companies and you don't have any contact details of individuals, then this does not count. However, be very mindful of the meaning of monitoring. Monitoring is a broad concept and it includes a wide range of activities. It includes, for example, dropping cookies on a website where you're using them to profile customers in the EEA. It includes the use of CCTV in the EEA, carrying out market surveys, behavioural advertising, and also geolocation tracking. So the same applies in reverse for EU businesses or businesses that are based outside of the UK, in that they may be caught by the extraterritorial effect of the UK GDPR. So, for example, if you have a business based and established outside of the UK, but they're monitoring the behaviour of individuals within the UK, then they'll be caught by UK GDPR. And just to quickly answer a question that we received before the webinar about Northern Ireland, it's worth clarifying that Northern Ireland is not within the EEA, and so if you're dealing with Northern Ireland, if you're concerned about Northern Ireland triggering EU GDPR, it will not. So the key takeaway is that if you're a UK business, you could be subject to both UK and EU GDPR, and you'll need to take steps to ensure that you comply with both. And if you are caught by both, then your obligations for now will be broadly similar. So any GDPR readiness project that you've already undertaken will still be relevant. You may just need to make some changes. And we'll explore in further detail further on in the webinar what these changes might look like. But for now, I'm going to hand back to Joanne to talk through the TCA. And as Joanne mentioned, she'll talk through what the TCA covers and also what it's silent on from a GDPR standpoint.
Thanks, Grace. So moving on to the next slide, the big issue, which I've alluded to at the beginning from a Brexit point of view, related to the export of personal data. Just to throw a few more facts and figures in, there is a 174 billion UK data economy and 75% of that involved transfers of data with EU countries. So you can imagine that it was important to make sure that data could continue to flow. So I'm going to have a look, as Grace said, at the TCA. The first thing I'll do, though, is just sort of put a couple of misconceptions to bed. The first one is, what exactly is data export? And I regularly get this thrown at me or a question asked about this. Data export, there is a perception that for it to be data export, the data has to be bundled up, put on a file, sent from one country to another. And that's certainly not the case. And helpfully, the European Data Protection Board has made it clear what data export can be in recent guidance. So if, for example, you have got personal data on a server in the UK, but you've got a service provider who might be accessing it in France, then there's still an export of that personal data to France. Access to the personal data can be export. As I say, it doesn't have to be bundled up and sent across as a file. The other misconception that we see quite a bit relates to whether data export can apply on an intra-group basis. So if you've got a number of group companies and you might have, say, a centralised HR function and personal data is going between the companies to this HR function, is that data export? And it is. It does apply both for external service providers or transfer of data externally and within groups. So if you do have centralised service functions, you do need to think carefully about data export issues. So moving on to the next slide, in terms of what the TCA applies to, what it doesn't apply to. If we can go back up to the previous slide, sorry. The TCA was agreed on Christmas Eve, and it certainly gave us some breathing space in relation to data export issues, and I personally was very happy about that because it meant I wasn't drafting a load of standard contractual clauses over Christmas. It took effect, I put on the 1st of January, I think technically it took effect at 11 o'clock on the 31st of December 2020, and it's over 1,000 pages of very dense text. So if anyone has insomnia and fancies something to send them to sleep, the TCA is certainly the thing that will do it for you. And it's quite a hard read as well. I've taken the approach of the Fisheries Minister and decided to just read the bits that are relevant and to not read the deal as a whole, because it is a very hard read, even for sort of a geeky lawyer like me. But if you are interested, obviously there's an awful lot of detail in the TCA. The main focus from a data protection point of view was export of personal data from the EEA to the UK. It didn't particularly look at the export of personal data from the UK to the EEA because the UK government had already said that was okay. The main sticking point, which was causing businesses to be quite concerned before Christmas, was whether or not personal data from the EEA could come on shore to the UK. And as I said, one of the main issues that a number of businesses was having related to intergroup transfers with centralised centralised service functions. As you'll see from the slide, the TCA doesn't cover everything. I think at one point there was a thought that what the TCA might do is just say it's going to be business as usual between the EEA and the UK from a data protection point of view, but that's not been the case. It does focus on export, but it doesn't cover the issues such as whether or not a representative is needed, the issue about one-stop shop, and also the potential of double jeopardy of fines. And that's something that we are going to have a look at a little bit later. So keeping on with the theme of export, moving on to the next slide, is that essentially what the issue was from an export point of view is that once the transition or implementation period had finished, the UK would become a third country from an EEA perspective. And what that means is it's essentially a country outside the EEA. So we were going to be in the same position as the US. And for anybody who has been watching the issues surrounding export of personal data to the US throughout the summer and the autumn, will know that it's not an easy thing. So in order for personal data to be sent to a third country, there have to be additional hoops which are jumped through in relation to the export. And they fall into three broad categories, so that if the country that the personal data is going to from the EEA has a finding of adequacy, then the personal data can move to that jurisdiction. And there is a list of a number of countries who have got adequacy which is available. It's a mixed bag of countries, such as Israel, New Zealand, Uruguay, Channel Islands, or certainly Jersey and Guernsey, Isle of Man, etc. But there's a defined list. There are also limited adequacy findings. So in relation to, say, Canada, it is a limited adequacy finding. So it's always worth double checking the list to see who's on it, and also what the scope of the adequacy finding is if you're going to rely on it. And certainly, as you'll see on the slide, adequacy is what the UK is looking for. If a country doesn't have adequacy, then there are two other options. The first is for the transfer to be subject to safeguards. And as you'll see on the slides, I've listed out some of the more common safeguards that can be used by business. So you've got standard contractual clauses, and I think more than 80% of transfers subject to safeguards are done on standard contractual clauses. You've also got binding corporate rules, and I've also mentioned certification schemes and codes of conduct, but they don't currently exist, although I do understand that that is something that is being expedited, particularly following the Schrems 2 case, which affected data export in the summer. Anybody, I'm not going to go into Schrems in detail today, because otherwise we'd need a lot longer than an hour. But for anybody that hasn't attended our Schrems 2 webinar, it is available on our Brexit Hub on our website. The other option, if you're not able to rely on adequacy or safeguards, are individual exemptions. And you'll see that there are certain derogations, but they are not meant to be used for ongoing regular transfers of personal data. So that's essentially what the position is in relation to third countries. So what does the TCA say? So moving on to the next slide, you'll see that essentially the TCA has said that for a period of between 4 and 6 months, probably I suspect more like 6 months. So there's an initial 4-month period which can be extended to 6 months. Data can continue to flow from the EEA to the UK. I I think they've started to call this period the bridge. And so during this bridging period, I think it's probably best seen as some breathing space for businesses for personal data to continue to come from the EEA to the UK. Now, during this bridging period, what the idea is that the UK will be reviewed by the Commission to see whether or not it provides adequate protections for personal data and therefore adequacy can be given. The reason why I say I think it's a breathing space is that I'm not sure that adequacy is a done deal. And there's a list of things which have to be thought about under Article 45 in terms of whether or not adequacy will be given. And one of the things that is considered relates to the potential of the security services for surveillance, to carry out surveillance. And certainly in the autumn last year, there was a European Court decision in which the extent of the surveillance carried out by the UK, France and Belgium was said to be over and above what was required from a strict legal point of view. So obviously, in terms of if that is something that caused a problem then, it is entirely possible that it could cause a problem in terms of the adequacy review. And it would be interesting to see what's likely to happen in relation to that. So I don't think you can see this period under the TCA, the bridging period, as being a period during which adequacy will definitely be given. It is possible that adequacy won't be given, which obviously raises the question over what should you therefore do. So moving on to the next slide. There was a suggestion when the TCA was first agreed by the ICO that businesses should use the 6-month period in relation to putting in place standard contractual clauses. Interestingly, they've pulled back from that position, and there is some new guidance in relation to Brexit and the TCA on the ICO website, which is pretty helpful. And what they've said is essentially what my personal view was, is to wait and see, so that what you do is monitor how the adequacy discussions are going, and if it looks likely, maybe by Easter-ish next year, sorry, this year now, isn't it? If it looks like it's going well by Easter this year, then what you can do is just wait and hope that adequacy will therefore follow through. If it looks like things aren't going so well by April time this year, then start to think about putting in place standard contractual clauses. I would suggest that you don't start putting in place standard contractual clauses now as backup, because for anybody that's had to put them in place, you'll know that whilst they are standard, there are some bits that do need to be tailored. There's management time, potential legal costs involved in doing it, negotiation discussions and things. So I would do, as I say, what the ICO has also now suggested, which is to wait until sort of Easter time, April time, and see how adequacy discussions are going. Now, I really don't want to sound like the voice of doom, but the other thing that I will just flag with you is that even if adequacy is given, it might not be the end of the story. Now, fingers crossed that it is, because it will certainly make life easier in terms of the transfer of personal data from the EEA to the UK. But there have been rumblings amongst privacy campaigners that they don't think that it's appropriate for the UK to get adequacy. And so it is possible that even if we are given adequacy, that there are privacy campaigners along the lines of Schrems who may therefore challenge it in the same way that Safe Harbour and Privacy Shield were challenged in relation to the US. I'll just sort of park that as an issue and just raise it as a possibility. As I say, I have no idea whether that will definitely happen, and I don't want to sound like the voice of doom, but it is something to consider in terms of whether once adequacy is given. Now, in terms of moving on to the next slide, what the TCA and adequacy will apply to, as I've said, it is transfer from the EEA to the UK. Now, as you can imagine, there are lots of data flows which go in different directions. So what I've done is put on the slide other transfers of personal data or export of personal data which need to be considered. So I think, as I've already said, in relation to sending personal data from the UK to EEA countries, that is something which the government has said they are fine with at the moment. And so what the position was pre-Brexit will be the position post-Brexit. The one thing to bear in mind, which I've sort of alluded to on the slide by saying for now, is that the government have said that this will be kept under review. I don't think that it will be something that will be deviated from, that they'll change particularly, because I think in terms of maintaining the flow of personal data from the UK to the EEA, if we're wanting adequacy, if we stop that and change things in relation to that, then obviously it's likely to cause us a problem from an adequacy point of view. In terms of the export of personal data from the UK to countries outside the EEA, then essentially the position is as was before. And so if you are sending it to a country where they had an adequacy decision, then the UK government has said that they will recognise those adequacy decisions. And that also includes Japan. Japan was one of the later countries which got adequacy, and so there was some question mark over whether or not, with it being one of the countries to get it later and it being fairly recent, whether or not that would be whether Japan would be recognised. But the UK has said all countries, including Japan, where there is an existing adequacy decision, will be recognised, and personal data can go from the UK to those jurisdictions. In relation to countries outside the EEA without an adequacy decision, then that should already be something which you are dealing with. So, for example, you might have put standard contractual clauses in place, and the position is the same, as I say, and so standard contractual clauses or other safeguards will need to be put in place with those countries. In terms of whether or not countries outside the EEA can transfer personal data to the UK, I think one important point to note is that adequacy will not help with that. Adequacy isn't a recognition generally that the UK provides adequate protection for personal data, and so it will only help, if we get it, for exports from the EEA to the UK. So if it's coming from a country outside the EEA, then the laws of those individual countries will be the ones that will determine whether or not the personal data can be sent to the UK. Now, certainly in relation to the countries where we have got adequacy with them, there have been discussions with those countries to see whether or not they are also prepared to agree that personal data can flow to the UK. And there is a list on the ICO website that explains which countries we've managed to do a deal with and which countries the position is outstanding. But certainly there has been recognition that the UK is adequate from the point of view of Jersey, Japan, I think Argentina is another one, and there is a list, so it's worth having a look on there. And I think negotiations are ongoing with the other countries. So if you are wanting to bring personal data into the UK from those countries, it's worth having a look at the ICO's website in terms of where negotiations have got to with those countries. So I'm now going to hand over to Grace, and she's going to have a look at some of the issues which relate to data protection and Brexit, which aren't covered by the TCA.
Okay, thanks, Joanne. So some bad news from me now. As a result of there being two separate data protection regimes, businesses and organisations now run the risk of facing heavier fines. So set out on this slide, you'll see the maximum fines that may be issued under each regime. Most of you will be familiar with these already, and of course on first glance they can look pretty devastating. However, in most cases it is unlikely that either the EEA or the UK authorities will issue fines up to these theoretical maximums. But of course, the point being, if you have two regulators who are assessing your activity instead of one, then the implication is that, of course, the total penalty imposed could potentially be higher than if only one regulator was assessing your activities. Okay, moving on to the next slide, another change. And this really ties in with the revised position on fines. So it follows that if you have two regulators that can issue fines, then of course this signifies the end of the one-stop shop concept under GDPR. So the one-stop shop concept was designed so that controllers and processors inside the EEA, which carried out processing that affected individuals in more than one EU or EEA state, only needed to deal with a single EEA data protection regulatory authority. This is no longer the case. Following the end of the Brexit transition period, UK businesses no longer benefit from the one-stop shop. And so what this means is that if you're a business and you're caught by EU GDPR based on the analysis that we ran through earlier in the webinar, then you may well have to deal with both the ICO in the UK and also the supervisory authority in any other applicable EU or EEA state where you are established. That's of course in the event of an issue arising. And this is particularly relevant at the moment. One recent example that demonstrates this in practice is the ICO's recent announcement that they are going to look into the sharing of personal data between Facebook and WhatsApp. Now, this was previously being looked into by the Irish regulator, the DPC. However, as a result of the one-stop shop, it's now possible. So the ICO are now able to, and they have decided that they're going to investigate this also. So what else might you need to consider? Well, there has been a little bit of confusion around whether UK businesses will still need to appoint an EU representative. Joanne, is this something that businesses still need to consider?
Yes, it is. Thanks, Grace. Essentially, as I say, there was a bit of a misconception at the outset that the TCA would change everything, and that would also mean that business could go on as usual and that a representative wouldn't be needed. But that's not the case. It doesn't deal with the representative point. So essentially moving on to the next slide, and then I think the next one after that, we're asked quite a lot about whether or not there is a need for a local representative. And I think the thing to bear in mind, and we can have a look at the rules around that, but the thing to bear in mind is that it needs to be thought about not just from the point of view of whether or not a UK company will need an EEA representative, but also whether an EU company will need a UK representative, and I think that's something that's quite often overlooked. In terms of whether or not a UK company might need an EU or EEA representative, the question is largely driven, there's two parts to the question, and the first part is, are you caught by the extraterritorial effect? Now, Grace has talked about that in terms of, are you caught by the extraterritorial effect of EU GDPR? And that obviously, as Grace said, looks at whether there's an establishment in the EU, whether you're selling to individuals, goods or services, or whether you're monitoring the behaviour of individuals. One of the questions we've had actually in relation to the extraterritorial effect point that Grace was raising earlier is whether or not, if, for example, you actually deal with companies, but you have an email address that identifies somebody, so like my email address is joanne.bone@irwinmitchell.com. Obviously, that email address identifies me. And the question we've had is that personal data? Certainly it is personal data, and the ICO has been clear in guidance around business to business rules relating to personal data, that will still comprise personal data. Whether that will potentially trigger the extraterritorial effect point is an interesting one, because if, for example, that individual is within a company and you're selling to the company, as Grace said, you're not selling to that individual. So the only thing that's likely to potentially trigger, if you're holding that sort of thing, whether or not the extraterritorial effect rules apply, is whether or not you're monitoring the behaviour of that data subject. Because if you're not selling to them as an individual, as Grace said, you're selling to the company they work for, notwithstanding the fact that that's personal data, it won't trigger the extraterritorial effect. So on the assumption, so that's the first hurdle in terms of are you caught by the extraterritorial effect of EU GDPR? The next question, and then the sort of first answer is, if that's the case, then yes, you will need a representative, unless the second sort of limb of the issue arises, which is whether or not you fall within an exemption. There's one clear exemption, and that is you do not need a representative if you are a public authority. The one thing I will say for anybody that is watching the webinar, and I know there are a number of people that potentially, say from educational institutions or sort of from local authority bodies and things, public authority is not defined. There is some guidance which you can extrapolate, looking at things like the Freedom of Information Act, but certainly there is not, which would be helpful of course, there is not a list of this is a public authority or public body, this is not a public authority. So if assuming that you're not a public body, then the question is, in terms of the exemption, you don't need a representative where essentially you are doing what you are in terms of the processing of the personal data is occasional. There isn't much special category or criminal conviction data, and what you are doing is not likely to result in a risk to the rights and freedoms of the individuals. So essentially what you have to do is you have to consider whether or not you're caught by the extraterritorial effect. Then you consider in terms of the sorts of personal data that you're processing, and does that mean that you fall within the exemption. If you do need a representative, then certainly we are seeing a lot of people, if they have got EU-based or EEA-based group companies, asking whether or not a group company can be appointed as a representative. And certainly this is permissible. I think the one thing that I would say is that the role of a representative is, as the word means, is to represent you, so that they have to be there to liaise with individuals within the EEA. So they have to be the first point of contact and have to be mentioned in your privacy notice, and also they are there in relation to liaison with the regulator in that particular country. So if you are going to use a group company based in the EEA, then you need to be happy that they can provide that service for you. If you don't have a group company, or you'd rather not use a group company, then there are commercial organisations which provide the service. Any appointment of a representative should be in writing, and strictly speaking, any representative should be in a country where you have the majority of individuals that mean that you are triggered into needing a representative. So it does need some sort of thought through in terms of who's the best person to do it and where are they best located. I appreciate that this can be a bit complicated in terms of juggling the extraterritorial effect and also the exemption. So we've put together a flowchart which is on our Brexit hub on the website to hopefully lead you through the process. As you'll see on the slide, we've been asked about an allied question relating to a data protection officer. Now, certainly the need for a data protection officer was something that came out of GDPR, and a number of groups have selected one data protection officer or DPO for the whole group. Now that raises a question in terms of, for example, if the DPO is based in the UK and covers, say, France, Germany, etc., then can they still be the DPO for the EEA countries following Brexit? Now, there is certainly nothing in GDPR or any guidance that I've seen that say that can't be the case. So my view is that if you, for example, have got a UK-based DPO, but you do have other subsidiary companies which use that DPO which are EEA-based, then provided that DPO can meet the requirements under both UK GDPR and EU GDPR in relation to fulfilling that role, then there's absolutely no reason why you can't have a single DPO. Now, as I say, obviously things are in their infancy a bit at the moment on the basis the TCA was only really agreed just before Christmas, and so you know, there may be additional guidance that comes out in terms of the feasibility of this, but certainly at the moment my view is that this is possible. Now, while I'm talking about EU GDPR and UK GDPR, we have also been asked a question in relation to whether or not all the articles align, as Grace said. They are very closely aligned at the moment, and certainly the articles do align. For anybody that is interested to see what the differences between UK GDPR and EU GDPR are, then there is what's called a Keeling schedule which can be accessed from the ICO website that will essentially show you what all the differences are. And who's asked that question, I'm more than happy to send a link to that Keeling schedule if that would be useful. Okay, so in terms of the last thing we're going to look at, I'm going to hand back to Grace, who's going to have a look at one of the sort of technical things which has arisen from Brexit relating to updating GDPR documentation. Grace.
Okay, thanks, Joanne. So what changes might you need to make to your documentation? Next slide will show a summary of these changes. So you may find that you only need to make minor changes to your documentation, or you may find that you need to make a number of changes depending on the analysis that you carry out and that we ran through earlier in the webinar. If, based on the analysis that Joanne ran through in respect of appointing an EU representative, you decide that you do need to appoint one, then this will need to be reflected in any privacy notices that you have. This will ensure that any EEA-based individuals have an appropriate contact. For example, if they wish to make a data subject access request, then they have the ability to do so. You'll also need to think about any personal data that you receive from the EEA, and likewise, if you transfer any personal data to the EEA, then you'll also need to update the relevant section of your privacy notice with this. If you rely on compliance with laws under the GDPR for processing personal data, you might need to have a think about whether this is still appropriate. If you are caught by EU GDPR and you're relying on compliance with laws, then just be mindful that this technically would be laws of the member state, and so you may need to carry out some analysis and just reconsider the lawful bases and make sure that they are still all appropriate and applicable. If you refer to union law in your privacy notices or any other terminology needs updating, then be mindful to do that. If you've got Article 30 registers, then these will also need to be reviewed and updated accordingly, with most of the points that I covered above in terms of privacy notices. So reviewing the lawful bases that you rely on for processing personal data, any data exports that are captured within your Article 30 registers and need updating. And then finally, if you have any data protection impact assessments, they will also need to be reviewed. The supervisory authority used for consultation in your DPIA may need to be reviewed and updated if it's no longer appropriate, and then also the knock-on effect of any data flows in any DPIAs that you have. Okay, so that brings us to the end of the presentation. I can see that Joanne's already picked up a couple of the questions that we've received as we've gone through. But we have received a couple of others, so we do have time to run through these now. One of the questions, Joanne, that we've been asked is, is this all or nothing? So if you're a UK business and you provide services to UK data subjects, but you have only a handful of individuals in the EEA, do you need to be concerned with EU GDPR in its entirety, or is there any materiality threshold?
It's an interesting question, Grace, and there's nothing in GDPR that has the sort of materiality part of it that I can recall. I'm more than happy to go back and have a look at it. I mean, there is the materiality in the representative point, but I don't think there's materiality in relation to if you only have a handful of customers that you deal with. I think it is a bit sort of all or nothing. I mean, obviously there is a question mark over whether or not, if you sell essentially to 3 customers a year who are EEA based, whether or not you could go for a light touch to updating your documentation, for example. I mean, that's obviously a risk decision, but you know, it's something you might want to think about. So unfortunately, I think since the rationale behind the rules are that anyone that you are trading with within the EEA should get the same protection as if we were still in the EEA, I suspect that there isn't materiality to it, but from a practical point of view, as I say, you may choose not to do all bells and whistles in terms of, say, updating your documentation, etc., and may just take a light touch on a risk-based approach. But interesting point, actually, very interesting. I think we've also got another question relating to representatives, relating to education institutions. In terms of, I think the issue here is the first part of the LIN, in terms of if you are, for example, having students enrol who are international students and who are EEA based, and the extraterritorial jurisdiction point, which we've just been talking about, that will probably trigger it. I think the saving grace for you may well be in relation to the fact that a public authority, public body, doesn't need to have a representative, and then it sort of boils down to as to what is a public body. I suspect that most, say, FE colleges will be public bodies in terms of looking at the Freedom of Information Act sort of definition of what falls within it. So probably not, provided you are a public body, and I think that's there to try and make life easy for say colleges and universities and schools and things that may be involved in terms of international students. Hopefully that has answered that. So remarkably, for one of these webinars, we've actually got a bit more time. So if anybody does have any more questions, happy to answer them now. Hold on, we've just had another one come through. In relation to standard contractual clauses, yeah, what we've been asked is what standard contractual clauses should you use, where essentially the data exporter based in the EU is a processor and the data importer is in the UK. This is an interesting question because the standard contractual clauses that we have at the moment essentially deal with transfers from controller to controller and controller to processor. I think when they were put together, it was always thought that it would be the controller that would be exporting. Obviously, following Brexit, there are a number of organisations that, for example, might have got their data being hosted in Ireland, and so they've got a processor in Ireland. So it's not the controller based in the UK that's exporting, it's when potentially that data is accessed from the UK or sent back to the UK that you've got the processor exporting. So the difficulty under the existing clauses is they don't really cover that. The good news is that there are some new standard contractual clauses which have been put forward. I don't think they've been finally signed off yet, although there has been an opinion by the European Data Protection Board in relation to them, but I don't think they've gone through and been approved formally. And they will have export from in relation to processor and also processor controller. So when they're in force, they will help. Unfortunately, at the moment, the clauses we have don't help. And I think the other point to bear in mind, which also needs consideration, is once those new standard contractual clauses have been approved, which I think will be pretty soon, from a UK point of view, we also need them to be approved by the ICO as well. But I suspect that will be done. If you are using anyone that's using old standard contractual clauses, and when the new ones come out, you've got 12 months to transition to the new standard contractual clauses. But what you shouldn't do once they've been approved is set up new relationships on the old clauses. Essentially, you're meant to move to them immediately. And I think they will be quite good in terms of how they, one, facilitate additional sorts of data transfer, but also I think the contract is meant to be more modular to give a bit more flexibility in terms of how the contract is built. Another question that we've had is in relation to the qualifications required for a representative. There aren't any specific qualifications which have been referenced. And for anybody that's interested, there is some European Data Protection Board guidance in relation to the extraterritorial effect of GDPR and representatives, and it sets out, for example, the things you should have in your contract with your representative. They don't say that there are specific qualifications, but what they do say is you've got to have somebody that's going to be competent to represent you in terms of liaising with the regulators and also with data subjects. So, for example, if you your representative will need to deal with any data subject access requests that come through in terms of forward them on to you and liaise with the data subject in relation to it. So you've got to have somebody that knows what they're doing in relation to that, and also obviously you need somebody that if they're going to talk to the regulator, that they know what they're doing and that they're not going to let you down in terms of what they're going to say. So we've had some additional questions through. Just have a quick look. So we've got a question here in relation to personal data where there is no sharing or export from services in the UK, but there are global clients. And it's a question of what the responsibility of the clients are in terms of complying with data protection versus what the obligation is in relation to the service provider, I'm assuming. My understanding of this question is that, and happy to take this offline if I've misunderstood, is that essentially there's some sort of service provision in relation to global clients, and that the global clients themselves are the controllers of the personal data. Obviously, the global clients will have to meet any obligations they have in relation to the personal data. If it's then provided to the business, which is UK based, then if, for example, they're acting as a processor in relation to it, there are separate processor obligations under both UK GDPR and EU GDPR in relation to obligations that they have to meet. So essentially it's understanding what the controller obligations are in relation to the data when it comes, and the processor obligations when you receive it. So, for example, there's a more limited Article 30 register. There's the obligations in terms of what has to be in the contract. There are security obligations. If it's a controller transfer, then obviously each party will potentially have full-blown controller obligations. But as I say, more than happy to sort of take that offline if I've not quite understood what the scope of the question is. So we've also been asked a question about how to deal with prohibitions which you often see in client contracts, that personal data can't go outside the European Economic Area unless authorised in writing. Certainly, again, if it's a processor relationship, there are rules about what you can do about data export in a processor relationship, but it doesn't have to be a specific sort of authority in relation to each one. It could be a more sort of general essentially approval in relation to data export, and certainly what you can do is you could put some wording around it, particularly when we get adequacy, that essentially the prohibition on export outside the EEA doesn't apply to the UK where there is adequacy and in relation to certain things. So you can, I think, look at the clauses. It's not a clause that you just have to accept. I think you can tailor what your response is in relation to that. We've also had a question about the materiality point in terms of the nature of the data, as to if, for example, that the data relates to special category data, does that make it even more important that, for example, you comply with EU GDPR, for example? And I think the point there is, as we've said, I don't think there is a materiality, but there is potentially a commercial risk assessment that can be done. I would be more careful about taking a light touch approach if you have got special category data, because that's more likely to get you into trouble. So even though you have limited data, if it's special category data or criminal conviction data or criminal offence data, I would always be very, very careful of it, and I'd probably err on the side of caution in relation to compliance with EU GDPR. So we've also had a question about supervisory authorities in terms of the likelihood of things being handed over rather than both being involved. There are certainly rules relating to the one-stop shop in terms of supervisory authorities who should take responsibility within the EEA. Unfortunately, now we're outside of that. Then there's it's less clear cut in terms of whether or not a particular supervisory authority will step back and let one lead, or what will happen, as Grace has said, by the Facebook WhatsApp thing. I think it's a neat illustration as to what the loss of the one-stop shop means, in that, for example, the ICO has always been interested in relation to the data transfer from WhatsApp to Facebook, but has let the Irish DPC lead. Now we're outside and we're not bound by those rules about which supervisory authority takes precedence. Other supervisory authorities can get involved, so obviously it works that way, but also from a negative point of view, it potentially will impact on UK businesses. I mean, obviously, if you are just trading within the UK and you just have UK clients and you are not monitoring the behaviour of EEA individuals, there's no real scope for any other supervisory authority to get involved because you've got no EEA activity. I think the issue comes where obviously you're potentially operating both the UK and the EU. So I think we have been through all of the questions that have been sent through, so thank you. Obviously happy if anybody's got anything else. In the meantime, moving on through the slides, just to flag with you, obviously Grace and I are your hosts, and if you've got any questions, please give us a shout, but also to flag with you that this is one of a series of Brexit events, and we have got another one which is scheduled for the 10th of February, which is going to look at Brexit and intellectual property. Just going back to the questions, we have had a final question that I think we've got time to go through in terms of, can we recap the representative point in terms of, could a UK-based person be an EU representative, or does the EU representative have to reside in the EU? I don't think there's a residence requirement, but I think they're meant to be based in the EU, because the point of it is that they are, so in terms of from an individual point, I think they do have to be based in the EU, basically. I'll stop whittering. Essentially, the point is that they are in the EU, they can be contacted by individuals and the supervisory authorities, and essentially they are there for the supervisory authority to take action against. So appointing somebody in the UK to be an EU representative, I don't think will work, because the supervisory authority will think they're not within their jurisdiction for them to be able to fine. And the fining issue with representatives is an interesting one, because they are stated to be the first the first port of call with a fine. What isn't clear is whether they act as a PO box or whether essentially they actually get the fine, pay the fine, and then claim it back. But certainly they do want a representative to be in the EEA. Okay, so I think that's the end of the questions. Apologies if I'm looking to one side. Obviously, questions are flying in through the meeting chat. So I think that's the end of where we've got to. So all I've got left to say is thank you very much for attending. If you could fill in the speaker assessment and the feedback form, that would be fantastic. And if you have got any questions, we have got a special Brexit hub on the website, and certainly we've got some Brexit FAQs relating to all sorts of things, from trade tariffs through to there is one on data protection with the representative point flowchart. So thank you very much, everyone.